Okay, here we are on Unit 7, a quick summary of the federal and state laws pertaining to real estate. It all started in 1866 when the Civil Rights Act of 1866 was introduced, and this actually prohibits discrimination based on race in all real estate transactions. There are no exceptions, and that still stands today. And Mayer Company in 1965 came to court with a Supreme Court case. They refused to sell a home to Mr. Jones, who was black and was prosecuted under the Civil Rights Act of 1866. In 64, the Civil Rights Act was brought out and amended to end racial segregation in schools, workplaces, and public accommodations. It also prohibits discrimination based on race, colour, religion, or national origin in public accommodations, such as hotels, restaurants, gas stations, places of entertainment, and schools, and in public facilities and government-run facilities. And the four categories were race, colour, religion, and national origin. But private individuals in housing could still discriminate except for race. So they modified that in 1968, and they brought out the Fair Housing Act, part of the Civil Rights Act, in 68, beg your pardon. And in that particular one, they had discrimination in the sales, leasing, advertising, sales or rentals, financing or brokerage services. And it was based on race, colour, religion, sex and national origin. And then they amended it in 1988 to introduce handicap status and familial status. Remember, handicap status is any physical or mental impairment that interferes with normal life functioning. And familial status is families with children or under 18 or pregnant women. Age and marital class are not protected statuses. Here's a quick way of remembering what the protected classes are. We say fresh corn, familial status, race, sex, handicap, colour, religion, national origin. Discrimination in general, we can discriminate with smokers and pets and so forth. States, counties, municipalities may have extra laws or rules, but must all include the basic FHA rules. The Equal Credit Opportunity Act does include some categories that are not in the FHA, and we will cover that a little bit later. The Fair Housing poster is available from HUD. This should be displayed in any place which deals with rentals, sales, leasing, insurance, mortgages, title work to do with housing. It features the Equal Housing logo, and a statement pledging adherence to the Fair Housing Act must be displayed in all housing industry offices and easily seen. If a complaint is filed and the poster is not displayed, then the broker must prove that no discrimination occurred. You are guilty until you prove innocent if they come along and see this is not there. Just a little tip here, the Fair Housing logo, which is a little box with the two lines in it. If you're using this logo, it's been advised, use it all the time or don't use it at all. There's no requirement to use it, but if you do, use it in all your advertising. And there are two categories of housing covered that have to adhere to the Fair Housing Act. If the property is government owned, or if it is privately owned, but you're using an agent to sell it or rent it, or you're using advertising. And if you are owners of 4 or more single family housing units, then you cannot discriminate. Also, if you are a multifamily owner with anything larger than a 5-plex, or if you have a 4-plex but you do not reside in one. So an owner who has a 4-plex and does reside in one is exempt. The transactions that are exempted under the Act, they must meet two conditions. Number one, a real estate licensee was not involved and there was no discriminatory advertising. Also exempt is a single family or rental residential property provided the owner does not own more than 3 homes and does not sell 2 or more homes in 2 years. And the rental of a fourplex is okay, provided that the owner lives in one of the units. But the Civil Rights Act of 1866 on race still applies to all. You can be exempt under the familial status category if you can show that in a complex like condominiums or a co-op, all the units have occupants of 62 years of age or older, or at least 80% of the units have one occupant of 55 years or older, and then you have published policies showing your intent for 55 plus housing. Non-protected classes, smokers, pets, married age. Just be careful when you start saying no to people. If you want to check on the communities that are eligible for 55 plus, you can go to the Florida Commission on Human Relations website. There are special exceptions. Religious organizations may restrict units of members to their religion, provided they do not discriminate in accepting membership in any of the other classes. And private clubs may restrict units to its members as well. We have prohibited activities, and that is steering home seekers away or to from specific neighborhoods. Blockbusting is when you go into an area and start a rumor of a protected class coming into the area, urging owners to sell. Redlining applies mostly to insurance, title company, loan officers, that you would either have different terms or conditions or refuse to work with homes in certain neighborhoods or a category of person. So it is against the law to refuse to rent to, sell, negotiate with, or deal with a member of a protected class, or to quote different terms, conditions, or privileges for buying or renting. You cannot advertise housing that is available to only a certain race or color, sex, religion, national origin, handicap status, or familial status. Or you cannot deny membership or the use of any real estate service to a protected class. You cannot make false statements concerning availability for housing, an inspection, rent, or sale. Enforcement of the Fair Housing Act. This is dealt with HUD and the Department of Justice. Complaints filed with HUD under the Fair Housing Act. You've got 1 year to file a complaint, and HUD can initiate their own complaint if they feel there's something going on. They will ask you to try and reconcile first. If not, then it will be handed over to the Department of Justice, and civil suits will be filed in the Federal District Court. And the responsibility and liability of the real estate licensees is assumption of truth in a complaint until you prove differently. Florida also has a Fair Housing Act, same protected classes as federal law. It may actually include extra classes, like where the money is coming from, maybe to pay rent or so forth, and whether you're a veteran or not, and 1 or 2 others. You need to check the state rules, and you also need to check your local county and even city rules. Usually the first offence is $10,000 for the first offence and $25,000 if you do it again within 5 years. We do have the Americans with Disabilities Act, which protects employment accessibility rights of individuals with mental and physical disabilities. Disabled persons cannot be denied access to public transportations, public accommodations, and commercial facilities. This includes real estate brokerage offices, even if it is located in your own private residence. And modifications may be required if it is shown they are readily achievable. This is a case-by-case basis with the ADA and the local authorities to decide whether you should modify your premises or not. We also have in Florida the Florida Americans with Disabilities Implementation Act. If we're advertising, selling land across state borders, we fall under the Interstate Land Sales Full Disclosure Act, and federal law that regulates the sale of lease of land outside the borders. It's administered by the Consumer Financial Protection Bureau, and certain developers must register developments and disclose to prospects facts regarding the real estate. There are 2 components. First of all, the registration requirement. If you're a developer and you're developing a subdivision of 100 or more lots, then you have to register with the CFPB. And if you're developing a subdivision of 25 or more lots, you must provide any potential purchasers or the purchaser with a property report before signing a contract. That person may cancel the contract within 7 days, and buyers who did not receive a report prior to signing the contract may cancel within 2 years. We have the Residential Landlord and Tenant Act. It places landlords and tenants on equitable legal basis. It protects both the landlords and tenants, and it applies to the rental of dwelling units. It doesn't apply to hotels or motels or mobile homes, and not to commercial leases. You must be 18 in Florida to enter into a rental agreement. First of all, we deal with deposits and advance rents for landlords. If the landlord is the one actually taking the money, they must account for the deposits and the advance rents. They've got 3 options. Hold the money in a separate non-interest bearing Florida bank account for the benefits of the tenant or tenants. Hold the money in a separate interest bearing Florida bank account and pay the tenant at least 75% interest or 5% per year simple interest. I should say at least 75% of the interest earned, or 5% per year simple interest. And post a bond with the court for the amount of security deposits and advance rents, or no more than $50,000, whichever is the less, and pay the tenant 5% per year simple interest. The landlord does not then have to hold the money in a separate account. If you're a landlord with 5 or more units, you must provide written notice to the tenant within 30 days of collecting the deposit where the money is going to be held, or where a bond has been posted, and whether the tenant is entitled to interest. You must give full disclosure. If a broker holds the funds on behalf of the landlord, the broker must abide by the licensed law regarding escrow funds. That is, make sure it goes into an escrow account 1 day for the agents, over to the broker, and broker into the escrow account within 3 days. Deposits and advance rents are trust funds that must be deposited into the broker's escrow account. It's a good idea to open up a separate escrow account for property management, but not required. But if you are doing that, then $5,000 of broker's funds to maintain the property management account is needed, or can be used. Sales associates must deliver rent and rental deposits to the broker by the end of the next business day. If you're renting to an active duty military person, you must approve or deny the rental application within 7 days. And if you don't, then it will be automatically approved. And they have to be notified in writing regarding approval or denial, plus give the reason. If you're the broker selling a home, or you are a seller selling a home, you've got to make sure that the security deposits and advance rents must be transferred to the new owner or to the property manager. Unless specifically stated in the lease agreement, the sale of the rented property does not terminate the lease. In other words, the lease will go with the house to the new buyer. New disclosure must be given to tenant as to where the funds will be held. Obligation to maintain premises. The landlord must meet the health and building codes of the property, provide working heat and running water, so not necessarily AC, provide insect and rodent extermination, provide garbage receptacles and pickup, and working smoke detectors. The tenant meets the health codes and building codes, and the tenant must use reasonable care in the operation of the equipment that comes with the house, and make sure that he does not disturb the peace of others, and make sure the guests behave themselves. The tenant must allow the landlords to enter the property to make inspections, provide services, to make repairs, and to show the property. The landlord may enter the property at any time in case of an emergency, otherwise obligated to give the tenant reasonable notice, at least 12 hours. If the tenant gives notice of extended absence, this does not entitle the landlord to go in and enter the premises unless in an emergency. With regarding the security deposits, when the landlord is holding a security deposit or has taken one, then the landlord's got 30 days to give notice as where the monies are held if that landlord has more than 5 rentals. 15 days to return the deposits if no claim is to be made when the lease ends. Or if they intend to make a claim, then they've got 30 days to send written notification by certified mail to the ex-tenant. And then the tenant has got 15 days to respond to the landlord's written claim. Any disputes will be handled between the tenant and the landlord in a civil court. And if you do have conflicting demands, you do not have to notify FREC, as previously mentioned in Chapter 5. There's no need to notify FREC that you've got a problem with who gets what. If you wish to terminate a rental agreement by the tenant, you've got a 7-day written notice by the tenant if the landlord fails to maintain the premises. The landlord has 7 days to correct the non-compliance, and the court, if they go to court, may allow the tenant to reduce the rent. Rent may be reduced by a court if the tenant desires to remain on the premises. You need to deliver a notice personally to the tenant, to the landlord rather, personally or mailed. Posted on the door shouldn't be there. If the rent is not being paid or the tenant has not actually been looking after the premises, then they may have a 7-day written notice or a 3-day business written notice for non-payment of rent, 3 business day. The notice will be personally delivered, mailed or posted on the door. You notify the tenant in 3 business days or 7 days if it's not for rent. After the time period up, file a complaint for eviction. The tenant then has 5 business days to respond to the complaint. If the tenant continues to occupy without responding, then you must obtain a final judgment for eviction from the court. You post a 24-hour notice. The sheriff will sign a writ of possession given to him by the judge, and then the landlord can then go in and remove items and change the locks. Okay, that's a quick run through of Chapter 7. We go through it in a little bit more detail in class. Thank you.